Well, thank you, Deputy Speaker, and I thank the member for that contribution. I've spoken on several occasions in this place about the importance of safe workplaces across Australia, here in this place for the staff that work here, through to every workplace across our country. Everyone deserves to have a workplace that they are safe in and that is respectful. And if there is harassment or misconduct or other issues in that workplace, there needs to be structures in place so that workers can raise their concerns if they wish to, and those concerns are addressed. And this bill takes action on a crucial piece of this puzzle. The bill will implement Recommendation 25 of the Respect at Work report, which is the final remaining recommendation that requires Commonwealth legislative reform. That recommendation was straightforward: to amend the Australian Human Rights Commission Act to insert a cost protection provision consistent with Section 570 of the Fair Work Act. The report noted that the inclusion of a provision of this kind should ensure costs may only be ordered against a party by the court if satisfied that the party instituted the proceedings vexatiously or without reasonable cause. In making this recommendation, the Commission expressed its concerns about the negative impact on access to justice, particularly for vulnerable members of the community, that came from the current costs regime that's associated with pursuing sexual harassment matters. And this is supported by parliamentary findings as well. The Commission highlighted the work of a 2008 Senate inquiry that acknowledged concerns that people making complaints may be deterred from taking forward claims in the courts because of the risk that they would incur substantial costs for the respondent. The background to this recommendation comes from the significant body of work that the Commission did in preparing its report, including Kate Jenkins, the former Sex Discrimination Commissioner. Ms Jenkins' time at the AHRC has now concluded, but I think she is still following closely and knows that the reforms that this parliament has seen in the last couple of years are due in many ways, in most ways, to the great work she did as Sex Discrimination Commissioner. Her willingness to be ambitious in recommending these necessary and overdue reforms is commendable, and the lives of Australians across our country will be better for it. So I am proud that this government has delivered on the recommendations from the Respect at Work report, turning that report and its recommendations into a reality and improving conditions for Australians. This bill does follow work that our government has undertaken from the start of our time in office to deliver on the recommendations of the Respect at Work report. Last year, in the early months of the government, we delivered the Respect at Work bill, which dealt with several matters that came from the Respect at Work report and its recommendations. I did say at the time of that bill, and I will say again, everyone deserves to feel safe and be safe in their workplace. It doesn't matter where in Australia you are, what kind of workplace you're in, the level of experience or seniority you have, how big your workplace is. You should be safe from harassment. There is no justification for harassment or other kinds of behaviour that have no place in Australian workplaces. We do know that too many Australians have experienced workplace harassment, one in three, based on findings from the AHRC. 40% of those are women and 25% of them are men. And in debate on the Respect at Work bill last year, one of the issues I spoke about was the stories shared with me by women about their experiences of harassment in the workplace. I do want to once again thank all those people who did share what are some very difficult stories and experiences with me. And those people who shared their experiences with the AHRC. Your courage in doing that has helped to inform this work and this very important legislative change. These are, in a large degree, happening because of the bravery you've shown. One of the issues that have come up time and time again in this has been the difficulty that workers have had in dealing with instances of harassment. The Respect at Work bill and this bill together aim to provide clarity on these issues to avoid more people feeling like they're lost or they're stuck in how they respond to workplace harassment. Of course, it shouldn't happen, but when it does happen, let's be real, when it does happen, we need to have the right response mechanisms in place. One of the barriers that people identified was the difficulty of the frameworks that were meant to support people but weren't doing that work. They are hard to navigate, they're complex, they're more focused on reacting to the situation than preventing it from occurring in the first place. And that extends to what this bill is trying to deal with. The issue of structures making it seem so much more difficult to get a resolution on an issue And because it seems so difficult that people give up without seeking that remedy, without seeking that resolution. We don't want people who have experienced sexual harassment facing the prospect of needing to pay the costs of a respondent in that harassment claim. It is a disincentive to people taking claims forward. So as this government has already done with previous legislation, we want to remove those barriers that in the past have left people stuck with no way forward after they've experienced sexual harassment in the workplace. The Respect at Work report heard that the risk of adverse cost orders acts as a disincentive to applicants considering pursuing their sexual harassment matters in the federal courts. The current practice in which costs generally follow the event, even while there is a broad judicial discretion to award costs in any matter seen fit, means that applicants may be liable for their own costs as well as those of the other party if they are unsuccessful. And the risk of being ordered to pay the costs of other parties to the proceedings can deter victim survivors of sexual harassment and other forms of discrimination from commencing legal proceedings. And of course, there is often a power imbalance here. Not always, but often you have an individual going up against a large corporation with many more resources. So it does create access to justice concerns, particularly for more vulnerable members of our community and people without access to substantial resources. In response to this problem, the Respect at Work report recommended that a cost protection provision be inserted in the Australian Human Rights Commission Act to provide greater certainty for applicants. I've spoken here before about Parliament doing this work to improve how workplaces across the country operate, as well as doing the work here in our Parliament to improve how we operate. We must in many ways be a model workplace. We haven't always been in the past, we're not there yet, but we are taking some steps to make this workplace as well a better place. And that's why this government has worked to deliver legislative change for Commonwealth parliamentary workplaces to ensure workers here in Parliament and in connected workplaces right around Australia have structures in place to prevent harassment and, importantly, to provide support to people when harassment does occur. I want to acknowledge the work of the presiding officers and the relevant ministers for the changes that have happened here. We are on the right track, I think, to become more of that model workplace that we should be and that we should aspire to. We've done some of the work, there's more to be done, and I do look forward to continuing to work with colleagues to make that happen. This bill would amend the Australian Human Rights Commission Act 1986 to insert a modified equal access cost protection provision, which would apply consistently across federal anti-discrimination laws. The reform will alleviate the significant barrier to justice that I've explained. That means that risk of adverse costs being awarded incentivises people from taking a claim forward. The bill would prevent courts from ordering an applicant to pay the respondent's costs except in certain circumstances. If an applicant is unsuccessful on all grounds, parties would generally bear their own costs. This bill picks up, as I said, on many of the recommendations in the Respect at Work report. The particular circumstances where the court may order that an applicant pay another party's costs are where it's satisfied that the applicant instituted the proceedings vexatiously or without reasonable cause, or the applicant's unreasonable act or omission caused the other party to incur the costs, or where all of the following apply: that the other party is a respondent who was successful in the proceedings, the respondent does not have a significant power advantage over the applicant, and the respondent does not have significant financial or other resources relative to the applicant. If the applicant is successful on one or more grounds, the court must order that the respondent pay the applicant's costs. However, if the court is satisfied that the applicant's unreasonable act or omission caused the applicant to incur costs, the court is not required to order the respondent to pay the costs incurred as a result of that act or omission. As I said earlier, this model addresses the power imbalances, the resource disparities that are present in many unlawful discrimination proceedings. The equal access model has been modified to recognise that not all respondents in unlawful discrimination matters are large corporations or well-resourced individuals. These modifications mean that the equal access approach can be effectively applied across all anti-discrimination laws without causing unintended consequences for one stream of complaints. These modifications are intended to reduce the burden on successful respondents that are not well-resourced and not at a power advantage over the applicant. which could include individual respondents or small businesses. And this approach to cost reform does differ from the hard cost neutrality model that was recommended in the Respect at Work report, and the soft cost neutrality model supported by the Australian Human Rights Commission in its 2021 Free and Equal Position paper. But there's a good reason for this, as I've just outlined, and where there are these differences in this approach that the government is taking with the bill, it is on the basis of wider consultation that we've done and taking into account the work of the Legal and Constitutional Affairs Legislation Committee in the other place and the work that they did on this. So after all of that consultation, the government considers that the modified equal access model strikes the appropriate balance between alleviating barriers to accessing justice for victim survivors and the burden on respondents, while not impacting applicants' access to legal representation. And the government has engaged with a range of stakeholders as we've been doing this work, including the ACTU, legal aid groups, the Australian Industry Group, the Australian Chamber of Commerce and Industry, and many others, and of course the Australian Human Rights Commission itself. There are a variety of views, but I think we did land in a spot where there is broad support for the place the government has landed on this reform and the importance of these reforms. So this bill is a big step forward in our government delivering on those recommendations of the Respect at Work report. It is part of us fulfilling our commitment to making sure we implement those recommendations in full. When our government says we will do something, we do follow through and we make it happen. We are ensuring that all workplaces in Australia can become model environments to support people to work safely and free from harassment. And with the changes in this bill, we are ensuring that if sexual harassment does still occur, there is a pathway through that is clear and does not obstruct people from trying to seek redress. So I commend this bill to the House.